Hi everyone. Sorry, my mic wasn't on. Hi everyone. Today I'm going to discuss an issue which I think should be top priority for the upcoming election. As you know, Roe v. Wade was overturned last year with the Dobbs decision, and I think that the decision was decided incorrectly. But I'm going to discuss that. I'm also going to give my recommendations for a strategic plan for securing women's reproductive rights at the federal level. And and that is basically to incorporate the Ninth Amendment. So I'm going to start out by reading some quotes from Ayn Rand. As you know, for those of you who listen to my channel, you know that Ayn Rand is one of my favorite philosophers. So let's get started. An embryo has no rights. Rights do not pertain to a potential, only to an actual being. A child cannot require a child cannot acquire any rights until it is born. The living take precedence over the not yet living or the unborn. Abortion is a moral right which should be left to the sole discretion of the woman involved. Morally, nothing other than her wish in the matter is to be considered. Who can conceivably have the right to dictate to her what disposition she is to make of the functions of her own body? Now, rights are based on a social contract, right? Um, Under common law, children were regarded as property. This is a completely relevant, but at no point did children have rights under common law, which I'm going to address when we get to the Dobbs decision. So, um, and they completely got it wrong when it came to common law. Common law, but rights are based on a social contract. So children don't have the capacity to enter a social contract. So the only rights that are to be protected are the rights of the parents, specifically the rights of the mother. Never mind the vicious nonsense of claiming that an embryo has a right to life. A piece of protoplasm has no rights and no life in a human sense of the term. One may argue about the latter stages of a pregnancy, but the essential issue concerns only the first 3 months. To equate a potential with an actual is vicious. To advocate the sacrifice of the latter to the former is unspeakable. Observed by ascribing rights to the unborn, i.e., the non living, the anti abortionists obliterate the rights of the living, the right of young people to set the course of their own life. The task of raising a child is a tremendous lifelong responsibility which no one should undertake unwittingly or unwillingly. Procreation is not a duty. Human beings are not stock farm animals. For conscientious persons, an unwanted pregnancy is a disaster. To oppose its termination is is to advocate sacrifice, not for the sake of anyone's benefit, but for the sake of misery, for the sake of forbidding happiness and fulfillment to living human beings. Which part did I want to address? Yeah, so Ayn Rand was against sacrifice. Her philosophy of objectivism was basically rational self-interest. So you're not supposed to subordinate yourself to anyone. Even if you are going to have children, you should be doing it because it's in your rational self-interest, because you love your children, because that's going to make you happy. But you don't have a duty to be an incubator for the state. If any among you are confused or taken in by the argument that the cells of an embryo are living human cells, remember that so are the cells of your body, including the cells of your skin, your tonsils, or your ruptured appendix, and that cutting them is murder according to the notions of that proposed law. Remember also that a potentially excuse me, remember also that a potentiality is not the equivalent of an actuality, and that a human being's life begins at birth. The question of abortion involves much more than the termination of pregnancy. It is a question of the entire life of the parents. As I have said before, parenthood is an enormous responsibility. It is an impossible responsibility for young people who are ambitious and struggling, but poor, particularly if they are intelligent and conscientious enough not to abandon their child on the doorstep nor to surrender it to adoption. For such young people, pregnancy is a death sentence. Parenthood would force them to give up their future and condemn them to a life of hopeless drudgery, of slavery to a child's physical and financial needs. The situation of an unwed mother abandoned by her lover is even worse. I cannot quite imagine the state of mind of a person who would wish to condemn a fellow human being to such a horror. I cannot project the degree of hatred required to make those women run around in crusades against abortion. Hatred is what they certainly project, not love for the embryos, which is a piece of nonsense no one could experience women's intensity. I would say that is an issue of self esteem and that their fear is metaphysical. Their hatred is directed against human beings as such, against the mind, against reason, against ambition, against success, against love, against any value that brings happiness to human life, in compliance with the dishonesty that dominates today's intellectual field. They call themselves pro life. But by what right does anyone claim the power to dispose of the lives of others to dictate their personal choices? Now, I would concur with this 100%. Those who are anti-choice. They call themselves pro-life, but really they just hate women. And not only do they hate women, but they also hate children because they know that these children are going to live miserable lives and they don't care, right? They just basically want more slaves for this capitalistic system. They don't care about your quality of life. They just want you to be born, and then afterwards, you're basically on your own to figure out how you're going to navigate through this drudgery. So, let me see. Do I have any comments? No. Okay, we had three people here. Great. So now let's go ahead and get to the Dobbs decision because I'm going to break this down, y'all. I put a lot of thought into this. So this is the decision. Let me make sure y'all can see it. Okay, y'all can see it. Okay, Dobbs, state health officer of the Mississippi Department of Health, et al. Et al. Means and others. So there were other people. This is the shortened version of it. Jackson Women's Health Organization et al. So I'm not going to read this. This is a 213-page document. I'm only going to read a short excerpt. Okay. The court examines whether the right to obtain an abortion is rooted in a nation's history and tradition and whether it is an essential component of ordered liberty. The court finds that the right to abortion is not deeply rooted in a nation's history and tradition. The underlying theory on which Casey rested that the 14th Amendment's due process provides substantive as well as procedural protection for liberty has long been controversial. In deciding whether in deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our history and tradition and whether it is essential to the nation's scheme of ordered liberty. The court has been reluctant to recognize rights that are not mentioned in the Constitution. Guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. Excuse me, I need to take a drink, y'all. 1 second. Okay, so that part is partially correct. Casey and Roe v. Wade were decided based on the right to privacy, which is not enumerated, but I'm going to address that. Um, according to Ann Coulter, civil rights are for the blacks. And what that means is that the 13th, the 14th, and the 15th Amendments were supposed to only apply to slaves and their descendants. Now, the Supreme Court expanded the 14th Amendment to apply to everybody, and they created this doctrine called substantive due process, and they created all of these rights based on penumbras, which I've mentioned penumbras to y'all before. So we have enumerated rights that are actually expressed in the Constitution, and then penumbras are rights that are not enumerated, but they are essential for expressing the enumerated rights. So, for example, an NAACP, NAACP versus Alabama, that was a case decided based on the right to freedom of association. The state of Alabama wanted the NAACP to release a list of their members, and the Supreme Court held that they could not do that because if the NAACP released the members of their organization, that would have a chilling effect on their free exercise of freedom of association. Basically, nobody would express their First Amendment rights because they would fear retaliation. So, although right to privacy is not articulated in the First Amendment, the U.S. Supreme Court held that freedom of association entails a right to privacy. Okay, so there's two parts that I want to address. First, the first one is that the right to abortion is not deeply rooted in the nation's history. And then the second part, this went down too far. Oh, that they were the U.S. Supreme Court was refusing to recognize rights that are not enumerated in the Constitution. That part is completely wrong. Hello, how are you? Okay, so we're going to address that because under common law, although there was no right to abortion, there was a common law right to infanticide. And I know most people would be horrified, but there are evolving standards of decency. And well before abortion, the family planning method was infanticide. People left their children out in the woods to die. So, for all those who are so outraged by abortion, really need to think about how far we have come. We have medical advances which precludes infanticide, which is what most people did back in the day when they didn't want their children. So, here is a law review. Let me make sure y'all can see it. Okay, there's the law review. Marquette Law Review. It's called Legal Concept of Human Life, the Infanticide Doctrines. The 19th century in England witnessed a series of alleged infanticides committed by unwed mothers out of fear of embarrassment while or immediately after giving birth to their illegitimate offspring. Rex versus Poltron in 1832 was one of the first early such cases to come before the courts. Anne Polton, the defendant therein, was accused of killing her child by strangulation, but it was not clear from the facts whether the child had died before or after the birth had been completed. There was medical testimony to the effect that the child had breathed before expiring, but the medical witnesses were unable to give witnesses as to whether the breathing took place during or after the process of birth. The court of Old Bailey began its summation to the jury by holding that a conviction of homicide was not possible unless the subject of the homicide was alive. That is, unless the infant in the case had been born alive. Being born alive, the court continued, requires the whole body is brought into the world, and it is not sufficient that the child respires in the process of the birth. This was common law, y'all. You have to actually be born alive in order for it to be considered a homicide. 1 year later, in a similar case, Rex versus Enoch, at the Worcester Assizes, the court also held that a complete birth was necessary before a child could be sufficiently alive to be the subject of a murder. It was used as the criterion in the live birth of the establishment of an independent circulation in the child. The following year, at the Oxford Assizes, the court in Rex v. Brain heard a case in which the medical evidence tended to prove that the decedent child had not breathed before his death, while again requiring the child to be wholly in the world in a living state to be subject of a charge of murder. The court did not consider breathing to be essential, since many children are born alive and yet do not breathe for some time after their birth. Thus far developed, the English common law of infanticide required complete live birth as determined by independent circulation, which could not be proved or disproved merely by evidence of breathing or not breathing. All convictions for infanticide required live births, and the supposedly medical criterion of an independent circulation was the favorite view from about 1980 on. Proof of breeding was usually considered relevant but not conclusive in determining the question of independent circulation. Due to the secrecy surrounding most of these births, there were rarely witnesses who could testify as to facts that could determine whether or not the victim had established an independent circulation. Postmortem tests were not always inconclusive since the legal requirements for an independent circulation had never been spelled out. Judges and juries often took advantage of these difficulties of proof, acquitting defendants whenever possible. Even in the rare cases of convictions, the inflexible practice soon became to reprieve any mother who had killed her child before it had lived a full year. Okay, this is the last bit. This is referring to American law. That was referring to English common law. In the United States, the law of infanticide developed in a more complex fashion than it had in England. With more jurisdictions, there was more room for differing views on the necessity of live birth, the relevance of breathing, and the meaning of independent circulation. As of the end of the 19th century, there was no authoritative view of infanticide that had been adopted by the courts. By the middle of the 20th century, however, a majority view had a minority, excuse me, a majority view and a minority view had been established, the former requiring live birth and the latter requiring only viability of the infant. The majority American view was an elaborated version of the Old English doctrine. The requirement of live birth was usually said to be based on the necessity of proving corpus delicti. Now, corpus delicti is a common law doctrine. Corpus delicti basically means that there has to be a victim in order to be a crime. A lot of people, those sovereign citizens, the Moors, they argue corpus delicti because there is no victim. So if you go over the speed limit, there is no victim, therefore there is no crime. So that's what corpus delicti means. Um, which was generally considered to be as essential in cases of homicide as in other cases, unless the subject of the supposed homicide had been a living person. It was said that there were there excuse me, I'm reading it was said there logically could be no murder and therefore no murderer. Most courts insisted upon a complete live birth to establish the corpus delicti, and upon proof of independent circulation to establish the live birth. Okay, so that's it. So this is English common law. Um, and this is the American law that was adopted. Um, there had to be a live birth in order to be an infanticide. So that completely rules out abortion. Now the Supreme Court said there was no precedence for it. Absolutely not. That's completely wrong. Infanticide was widely practiced, and they're making it seem like abortion is something that just started with Roe v. Wade. No, this happened way before Roe v. Wade. Okay, y'all. I'm going to get this is not the most interesting topic, but this is important because this is a strategy that needs to be discussed in the upcoming election. Like this needs to be the primary focus of candidates. They need to be put on the spot to address how they're going to protect women's reproductive rights. And I think the way to get there is through the Ninth Amendment. Okay, so here's the Ninth Amendment. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Okay, so let's go back to what the Supreme Court said. The court has been reluctant to recognize rights that are not mentioned in the Constitution. Now, let's go back to what the Ninth Amendment says. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, the reason that the Ninth Amendment was put there because okay, so we have Federalists and we have anti-Federalists. The Federalists wanted a strong centralized government. The anti-Federalists did not want a centralized government. They wanted the power to be retained by the states, and they were also against the Bill of Rights. And the reason that they were against the Bill of Rights is because they believed that if we had an enumeration of rights, that would lead to an interpretation that the only rights that people retained were those that were spelled out in the Bill of Rights. So they basically said we should not have a Bill of Rights. All of the rights that the people had under common law should be retained by the people. So that was the purpose of this Ninth Amendment. That was the compromise. It specifically says that the enumeration of the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Now, to me, this is very clear. So many people have different opinions about this, but what it says to me is that our rights do not come from the Constitution. Our rights come from natural law. The Constitution is simply a non-exhaustive enumeration of certain rights. The Constitution does not create rights, which is what the Supreme Court got wrong. They said that that the courts refuse to recognize rights that are not enumerated. No, no, the Constitution only enumerates certain rights. Okay, let me see if I have any comments, and I'm going to the next bit. No, no. Okay. So the reason why incorporating the Ninth Amendment is important is because the U.S. Constitution only applies to the federal government, right? The U.S. Constitution doesn't apply to the states. The only exceptions is when the U.S. Supreme Court incorporates it through the 14th Amendment. Again, the 14th Amendment was only supposed to apply to slaves and their defendants. I mean, and their descendants, excuse me. But they expanded the 14th Amendment to include procedural due process as well as substantive due process, which Clarence Thomas rejected in his concurring opinion. Basically, the conservative Supreme Court wants to reject all substantive due process rights. And substantive due process rights are those unenumerated rights. The right to privacy, which includes the right to abortion, the right to marry, um, the right to gay marriage, the right to family planning, um, the right to familiar. There's a whole list of substantive due process rights. They're all based on case law. It's not based on enumerated rights in the Constitution. Justice Brandeis and Justice Warren wrote a law review article, and it's basically the right to privacy and the right to be let alone. The right to let alone never really stuck, but the right to privacy was adopted by the court, and that is really the basis for the right to abortion and the right to same-sex marriage and the right to medical decisions and all that stuff. So the right to privacy is not listed in the Constitution, but it's based on penumbras. It's based on the Fourth Amendment right to protection from unreasonable searches and seizures, and it's based on the Ninth Amendment, which still hasn't been incorporated to apply to the states. But let's read this little bit because this is a footnote. U.S. versus U.S. Okay. No, let me. No, excuse me. The case is Osborne versus U.S. I was reading the wrong part. And there's a little footnote here. Footnote 15. It said the Ninth Amendment should be permitted to occupy its rightful place in the Constitution as a reminder at the end of the Bill of Rights that there exist rights other than those set out in the first 8 amendments. It was intended to preserve the underlying theory of the Constitutional Convention that individual rights exist independently of government, and to negate the Federalist argument that the enumeration of certain rights would imply the forfeiture of all rights, of all others. The Ninth Amendment is simply a rule of construction applicable to the entire Constitution. Okay, so the Ninth Amendment is a rule of construction. There are rights that exist independent of government. Our rights do not come from the Constitution. Our rights do not come from the government. But the way that it has been framed and the way that the Constitution has been interpreted is that the burden is on you to show that you have a right to do anything. And the presumption is that anything that the state does is legitimate. So they have a 3-tier test, which is rational rational basis, which is the lowest level of scrutiny, intermediate scrutiny, and then strict scrutiny. And so that's basically the test that's going to decide what level of protection you get. If it's strict scrutiny, then basically it's going to be deemed invalid in most cases. But most acts of government are based on rational basis. As long as the government has a rational state interest in whatever they do, then the burden is on you to show that you have a right to that specific activity. No, the burden should be on the state because you have a Ninth Amendment right to rights that are not enumerated, and the burden should be on the state to prove that they have authority to infringe on your rights. But no, that's not the way the Supreme Court has been interpreting this. So I'm going to go to Federalist Paper 84. Make sure y'all can see that. Okay, here's Federalist Paper 84. This is written by Alexander Hamilton. And this is referring to the Ninth Amendment. To the second, that is, to the pretended establishment of the common and state law by the Constitution, I answer that they are expressly made subject to such alterations and provisions as the legislature shall from time to time make concerning the same. They are therefore at any moment liable to repeal by ordinary legislative power, and of course have no constitutional sanction. The only use of the declaration was to recognize the ancient law and to remove doubts which might have been occasioned by the revolution. This consequently can be considered to be, this consequently can be considered as no part of a declaration of rights, which under our Constitution must be intended as limitations of the power of the government itself. So that's what I'm trying to tell y'all. The Constitution does not create rights. The purpose of the Constitution, or the Bill of Rights specifically, was to limit the government's power. And they're interpreting it completely wrong. They're saying our rights come from the Constitution. That's not what it is. It's limited. It's saying the government can't do certain things. It's not a declaration of rights. Here in the strictness, the people surrender nothing. As they retain everything, they have no need of particular reservations. We, the people of the United States, to secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution for the United States of America. Here is a bigger recognition of popular rights than volumes of those aphorisms which make the principal figure in several of our state Bill of Rights, and which would sound much better in a treatise of ethics than in a constitution of government. So it's okay. So aphorisms is basically things that are considered universally true. Um, so it's basically saying we know what our natural rights are. We know what rights we had under common law. Some things don't need to be spelled out. That's what the Ninth Amendment is saying. Those rights that you retain under common law, which I just showed y'all, there was a right to infanticide. They couldn't determine whether there was a live birth. And so usually the mother would not be prosecuted if the baby expired or the whatever. The same thing. The same thing. We're still talking about abortion, but what I'm saying is that common law went even further than today's legal protection for abortion because it went further to protect infanticide, that it was inconclusive to determine how the baby died. So they would not investigate. They would protect the woman's right to privacy. But a minute detail of particular rights is certainly far less applicable to a constitution like that under consideration, which is merely intended to regulate the general political interests of the nation, than a constitution which has the regulation of every species of personal and private concerns. If therefore the loud clamors against the plan of the convention on this score are well founded, no epithets of reprobation will be too strong for the constitution of the state. But the truth is that both of them contain all which, in relation to their subject, is reasonably to be desired. I go further and affirm that the Bill of Rights, in a sense and to the extent in which they are contended for, are not only unnecessary for the in the proposed Constitution. Again, he's saying that this is Alexander Hamilton saying that the Bill of Rights was unnecessary, um, but would even be dangerous. And the reason why they thought that the Bill of Rights would be dangerous is because they thought it would be interpreted to mean that those are the only rights that the people retain. So they didn't. This is the reason why they put the Ninth Amendment there. And for some reason, the courts are disregarding the Ninth Amendment. The Ninth Amendment is not taught in law school. They don't mention it. It's not tested on the bar exam. Most attorneys don't know anything about it. The Ninth Amendment is the forgotten amendment that everyone completely disregards. They would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than were granted. Again, because we have a Bill of Rights, they're saying those are the only rights that you retain, and then the government can run amok. Now they can regulate your body. Now they can tell you who you can and can't marry because according to the U.S. Supreme Court in a Dobbs decision, they only recognize rights which are enumerated. They don't recognize your common law rights under natural law. For why declare that things shall not be done, which there is no power to do? The states don't have the power to do it anyway. The states don't have general police powers. This is an okie doke. They always want to refer to the 10th Amendment talking about states' rights because when we're talking about big government, we're always talking about the federal government. No, the states are big government. The states are the ones that have general police powers. The states are the ones that are making our lives miserable. The states harass you when you're trying to buy groceries and pull you up. These road pirates, they regulate your body. They impose property taxes. They control whether you eat, sleep, or shit. It's the states that are a problem, not the federal government. The federal government, I mean, I don't know. I mean, I guess because the president is more prestigious, they get more media attention, so everyone focuses on the president and whatever is going on in Congress. But it's no, you need to focus on what is going on locally. It's the states that are making your life a living hell. The states don't have general police powers. This is a lie. Even the 10th Amendment says that powers that are not granted, and I'm not going verbatim, but basically powers that are not expressly given to the federal government are reserved to the states or the people. So even the 10th Amendment still reserves power to the people, not just to the states. The states only have powers which are enumerated. Let me finish this, and I have more commentary to say. Okay. Why, for instance, should it be said that the liberty of the press should not be restrained when no power is given by which restrictions may be imposed? I will not contend that such a provision will confer a regulating power, but it is evident that it would furnish to men disposed to usurp a plausible pretense for claiming that power. They're always going to claim it. See, um, when you're suing the state to protect your rights, the state really only has to express a state interest, and usually it's going to be rational basis. So even if it is pretextual, even though the state is lying, saying that, oh, we have an interest in protecting the unborn, or we have a, even when it comes to same-sex marriage, we have an interest in, I don't know what their interest would be in, sodomy used to be um a criminal act in many states, especially Texas, until 2003, Lawrence v. Texas. So, what was the state's interest in regulating people's private sexual conduct? And by the way, the Texas Attorney General Kenneth Paxton and it seems Clarence Thomas, they want to overturn Lawrence v. Texas. They want to recriminalize sodomy. So they want to regulate your private consensual sexual acts. Okay, so basically, there's a pretense for claiming a state interest. They might urge with some semblance of reason that the Constitution ought not to be charged with the absurdity of providing against the abuse of authority which was not given, and that the provision against restraining the liberty of the press afforded a clear implication that a power to prescribe proper regulations concerning it was intended to be vested in a national government. This may serve as a specimen of the numerous handles which would be given to the doctrine of constructive powers, but the indulgence of the injudicious zeal for the Bill of Rights. Okay. Oh, I do have one other bit. Okay, so that's the Federalist Paper. That's Federalist Paper 84. And basically, the reason why this is relevant because this basically gives us some context for the Ninth Amendment. Um, the Ninth Amendment was to ensure that they did not say that though only the enumerated rights in the Bill of Rights are our only rights. It's like, no, we retain all those rights under common law. And the state and local governments are usurping authority which it doesn't have. And we're just giving deference to them, saying, oh, you're the government, you can do whatever you want. I'm just going to roll over and defer to you and let you control my life and make my life a living hell. I don't think people even know anything about the Ninth Amendment. They don't know that they have common law rights. They don't know that they have rights under natural law. Um, this was barely mentioned in the Dobbs decision, but it was really cursory, and they just moved on. They, it was like a one-liner about the. No, that should have been a crux of it. And we need to incorporate the Ninth Amendment and apply it to the states, and make this. We need to make the Ninth Amendment relevant. Okay, I have one last bit. Let me see if I have any. Okay, I have one person still here. The original meaning of the Ninth Amendment. I guess I'm losing people. I'm sorry, y'all. I know this is boring stuff, but this is necessary. This is necessary because you guys don't know what your rights. If you don't know what your rights are, I don't know how you're going to protect them. Um, yeah, we're in a bad state when the government This is what Ayn Rand said. The ultimate inversion is when the government can do as it pleases and the citizen can only act with permission. Okay, so the older orthodoxy saw the amendment as part of a scheme for preserving the basic framework of the federal constitution, and in particular for preserving the concept of national government of limited and enumerated powers. The enumerated rights by this reading are the rights of the people reserved by the device of listing granted powers. But the traditional view does not lack a meaningful right focus. It simply holds that the drafters of the Constitution, the scheme of limited government embodied in a system of enumerated powers, was a means of reserving rights to the people. On this reading, the purpose of the Ninth Amendment was to ensure these reserved rights, what Madison called the great residentium of rights of the people possessed under the unamended Constitution against any adverse inference that might be drawn from the addition of a Bill of Rights. Again, the inference is that because we have a Bill of Rights, those are the only rights that the people retain. Okay, so I just want to read this last footnote. Raul Berger was a Harvard law professor, and he promoted the idea that traditional view ensures the reserved powers of the states. Um, he wrote that the unenumerated rights are exceptions to the grant of power, but are of a sub-constitutional nature and do not arise from the Constitution. Again, our rights do not come from the Constitution. This is the Constitution limits the government's power. It doesn't create rights. Relating unenumerated rights to Madison's stated purpose of ex- accepting out cases where government should not act. Rights retained are not embodied in Constitution, and suit alleging violation of such rights do not arise thereunder. Nevertheless, these rights exist independent of government and constitute an area beyond government power. There are areas beyond the scope of government power. The government does not have unfettered discretion to control whether you eat, sleep, or shit. This is this is tyranny. You can't even control your own reproductive functions. Okay, so that's all I have. I see I only have one person left. I don't know if anyone has any questions, but although this live stream is about reproductive freedom, I guess I have my own ulterior motives for wanting to incorporate the Ninth Amendment, and that is because state Supreme Courts are claiming inherent authority to regulate the practice of law. And based on this inherent authority, they're creating all these rules which have the same legal effect as codified statutes, right? They have no public oversight. There's no public debate. The state Supreme Court creates these rules based on its inherent authority to regulate the practice of law. They are arbitrarily keeping people out of the practice of law. They're creating all of this chaos with these rules that nobody knows except those who are in the practice of law. And so by incorporating the Ninth Amendment to say that powers which are not enumerated in the Constitution, you can't claim that you have inherent authority. So the jig is up. The scam that you're trying to run, the okey doke that you're trying to run on American people is over. We need to incorporate the Ninth Amendment. And to get back to women's reproductive rights, we don't need a state, we don't need a federal amendment in order to get protection for women's rights. When there's a federal statute or a federal bill that is proposed, there has to be an enabling act. There has to be some constitutional authority for that law. We already have constitutional authority. The constitutional authority is the Ninth Amendment. So, based on the Ninth Amendment, Congress can pass a law protecting the people's rights to unenumerated rights that they retain under common law to reproductive freedom. Congress can do this now. They keep making all these excuses. Stop focusing on the 14th Amendment. There is no substantive due process. If you go with the Ninth Amendment, that is an ironclad thing that even the Supreme Court, even the conservative Supreme Court can't really, there's no wiggle room with that. So the Ninth Amendment is the way to go. People need to learn about this. I'm going to be talking more about the Ninth Amendment. I know this is boring stuff. People don't want to listen because it's, I mean, I know it's not interesting, but at the end of the day, this is your life. If you don't know what your rights are, then you basically don't have any rights. You need to know what your rights are so that you know what to fight for. And very few people are very few people are going to tell you this. Very few people are even going to mention the Ninth Amendment. They don't even know what it is. They've never even looked at it. So unless anyone has any questions, I'm going to go ahead and end this live stream. Um, do you want to come up? If you want to come up, I can post a link. Let me go ahead and post a link. Okay, so there's a link. I'll wait a few minutes. If you have any questions, you have anything you want to say, are you still there? I don't know if you're there or not. I see somebody just left. All right. Well, it doesn't look like anybody's coming up, so hopefully you guys got something out of this live stream. Um, I'll be doing another one next weekend. Okay, so the person who just came in, I just posted that link. I don't know if you were the one asking to come up, but the link is there if you want to. Okay, here's a private comment. Okay, so I don't know if you want to click the link, you can. I'll give you a couple of minutes, and then I'm going to call it a night. Okay, well, it doesn't look like anybody's coming up, so y'all have a good night.